Good afternoon and welcome to the Hersch Lauterpacht Memorial Lectures 2020. The lectures are one of the highlights of our year at the Lauterpacht Centre. They are delivered annually on a person of eminence in the field of national who can make the unique contribution to the development of internationals. Hersch Lauterpacht. This year's lectures are particularly special. A few years ago, the Centre invited Professor Karen Knop, the Cecil A Wright Chair at the University of Toronto, to deliver the lectures. Professor Knop's work will be well known to many in this room. For example, her award-winning Diversity Self-Determination, or one of her last published pieces, The Beauty Written and Insightful Forward, looking at portraits. All of her work was marked by her characteristic originality of thought, eloquence in writing, and really helped us uncover new ways to see familiar issues. Professor Knop was also a wonderful friend, a supporter, and mentor to many. Here at Cambridge, we benefited from her warmth, intellect, and camaraderie, most recently in May of 2022. On that occasion, she spoke movingly in tribute to her doctoral supervisor, the late Professor and James Crawford, at the Crawford Memorial Conference, and copies of her remarks at that event are floating around. Professor Knop very sadly passed away just a few months later. As a tribute to her, the Centre has invited 4 former Hersch Lauterpacht Memorial Lecturers to deliver this year's lectures. The lectures are intended to engage with Karen's work on diversity and self-determination in 3 of the areas in which she wrote so brilliantly, namely history and theory, gender and feminism, and private and foreign relations law. And we are very grateful to Professors Christine Schenken, Martti Koskenniemi, and Aaron Peters for accepting our invitation. As a nod to Professor Knop's contribution to the discipline as mentor and supporter with younger scholars, each lecturer has been paired with a former student, friend, or colleague of Professor Knop to act as respondents or partner. And we are very, very grateful to Doctors Roxana Banu, Megan Donaldson, and Martin for accepting our invitation. As is the usual practice for lectures, we will hold off from discussion until the final session, when Professor Mark, herself the former Hersch Lauterpacht Memorial Lecturer, will tease out cross-cutting themes and open for discussion. I know that we are in a treat over the next 2 days. We are in for a treat over the next 2 days. So with that, I will hand over to my colleague and Deputy Director at the Centre, Professor Ranganathan, who is very much the architect of 2 days, to lead us into the first.
Good afternoon, everyone. It gives me great pleasure to introduce the speakers for the first session of this year's Hersch Lauterpacht Memorial Lectures in the honor of our friend and colleague, Karen Knop. It is something of a cliche to say that the people one is introducing need no introduction, but it could hardly be more accurate in this case. Our first speaker, Professor Martti Koskenniemi, is not only globally renowned for his scholarship in the history and politics of international law, but also has the rare distinction of being a scholar whose works are universally identifiable by one-word nicknames. So we could say Fatu, or Gentle, or Uttermost. Anyway, everyone knows what you're talking about. Professor Koskenniemi is Professor Emeritus at the University of Helsinki, Fellow of the British Academy, a member of the American Academy of Arts and Letters, and recipient of more major prizes and honors from leading learned societies in law and history, and I could count here. He is also a former Woodhart professor at Cambridge and delivered the Hersch Lauterpacht Lectures here in 1998. Martti, we are so pleased to welcome you to Cambridge. For Dr. Megan Donaldson, the Lauterpacht Centre is a former academic home. She spent 4 years here from 2015 to 2019 as a junior research fellow, jointly appointed by the Centre and by King's College. And this was following her doctorate degree at NYU. She is now an associate professor at University College London where she is consistently breaking new grounds in the heritage theory of international law. Important to mention from among her repertoire of writings is her article on the history of treaty making, which won the Francis Diaz Prize from the American Society of International Law. Her pivotal edited collection, together with Martti, called History, Politics, Law, Thinking Through the International, which carries a very fine chapter by Karen Knop. A recent symposium on Antonio Cassesi and the European tradition in the European Journal of International Law, and her forthcoming monograph, Secrecy, Publicity, and the Making of the International Legal Order, which is under contract with QUP. We know Megan here as the organizer of the wonderful Legal Histories Beyond the States series, and as a dear colleague that we're always very pleased to see walk through the front of the center. So welcome back. And now, continuing conversations with Karen's work, Martti.
Thank you so much, Surabhi. It's wonderful to be back in Cambridge. I was walking across the river. I was thinking, I'm going to see James again and have a conversation with him upstairs. Of course, not there any longer. And yeah, of course, as everyone knows, this is a special event that for which I take the floor with not a little sadness, because Karen is not here. We cannot hear her. But it's right for the center to have chosen this year's lectures in her memory. And it's in this spirit that I will do my best to reflect on one theme that we discussed with Karen during her visiting professorship at the University of Helsinki in 2020. She had just organized a conference on the lost public side of international law. She had for some time been interested in the way international lawyers reason using private law analogies, categories such as contract, territory, representation, succession, responsibility, and so on. And he suggested that these analogies prevented international lawyers from grappling seriously with the way in which domestic public laws of various states made them think differently about international law. And that this was especially regrettable in view of the conditions of the present backlash against international law and its. And prompted by those discussions, I have since then tried to work on this idea. What indeed is public law's role today in the international world especially? And what's its role for the crisis of democracy, visible in neoliberal globalization, erosion of public services, and interminable austerity, and political polarization and the rise of authoritarianism? All of these matters that Karen and I discussed in the cafes in Helsinki, often way later than we should have. Well, in thinking about such matters recently, I came across the massive 4-volume series of works, L'avènement de la démocratie, The Rise of Democracy, by the French historian and philosopher Marcel Gauchet. The summary of that work was published last year as Le Nœud de la démocratie. According to these works, democracy's problems are not caused by constitutional or institutional dysfunction. They cannot be corrected by more committees, conventions, or better governance, sticking to the rule of law. Neoliberal globalization is not the cause, but the symptom of the malaise deep within the transformation of late modern society. Gauchet offers an ambitious narration of the elements of the problems of democracy as found on pages in what he calls our être ensemble in modern society, live together in 3 respects. First, the constitution of public authority. Second, the system of horizontal relations between human beings. And thirdly, the temporality of the society in which we live. Following many others, Gauchet suggests that the history of modernity has meant the slow giving up of the sense that outside society there is a single center, la une, the one, he calls it, providing coherence and direction to social life. He suggests that in order to grapple with the crisis of democracy, we need to address those three problems. And that is what made me think of our discussions with Karen in Helsinki. I think these three problems were what she was also grappling with. For Gauchet, the origin of our problems lies way back in the exit from religion long ago that used to provide that unitary frame for society. Eventually, as Max Weber and the Weberians have suggested, religion was then replaced by other supposed givens: tradition, nationhood, civilization, capitalism, science, and ideologies of various kinds. But in recent past, and Gauchet suggests that between 1975 and 1985, something happened. At that point, as other French thinkers have suggested, society grew autonomous from vague narratives. Its elements were to produce now coherence from themselves, an assumption that fundamentally affected public authority, human relatedness, and our sense of social time. This is a complex story that Gauchet takes from the French Revolution to the present. Many of its elements are familiar from other stories, especially French ones. How is one to translate entre ensemble or structuration sociale, for example? I will bypass those and come directly to what Gauchet suggests happened with modern social life about half a century ago. Public authority first. When politics ceased being an effort to realize an idea external to society, it turned into the daily governance of problems, the adjustment of conflicting preferences of different social groups in view of electoral cycles. Politics turns into policy, especially economic policy. As the structure of social relations was no longer articulated by a single idea or meaning, nationhood, for example, it became articulated by law, especially by individual rights. Sam Moy. Claims of right provided the shared frame of social relations. And finally, the sense of history. As no single standpoint offered a continuity between the present, past, and future, social life would concentrate intensely on the here and now. The past was studied, yes, even intensely, and the present politics was oriented to the future. But no clear sense existed as to how those were linked to each other. What was it that justified projecting, as nationhood, for instance, had once done, continuity between the humans presently on this place and those who existed before and those who would come later? This was not, I think, intended as a conservative lament about things having become so much worse than they used to be. Gauchet wants to account for the experience that the political institutions and languages of the present are part of the problems of the present and therefore are not able to deal with the present. Or as Wendy Brown put it recently, they are saturated by the very assumptions and conceits generating many of our problems today. Liberalism, neoliberalism, capitalism, electoral democracy, legislation, and so on cannot be corrected by more governance, more investment into growth, and more fact-checking or rule of law. Our difficulties are symptoms of relatively recent social transformations, half a century or so. It was then that it became hard to explain what else would public authority stand for than some combination of special interests. And how on earth could social bonds be created on individual rights that provided for freedom from social bonds? And how the experiences of present generations could be used to justify future lives. Now, when I recently reread Karen's work, I noticed that she has something to say about each of such problems. Her writings dealt with complex issues of public authority, rights, and identity, the relationship of the present to history. She was well aware that liberal accounts of political authority were open-ended and contradictory, and therefore amenable to conservative backlash as well as constructive reimagining. She did not think that self-determination meant that each people possessed a script waiting to be made real. Groups had to construct themselves from their elements. Public authority arose from stories that narrated those elements into a larger story where group members would necessarily have to be other than mere preference aggregating egoists. They were involved in cultures employing resources of past generations to create better lives for the future. Let me now say something about Karen's work in relation to each of these three types of issue or problem. Public authority first. State sovereignty is founded on a rejection of the view that humankind is related by one idea. Also, the rejection of imperialism. But sovereignty and the supporting doctrine of nationalism has in the past 50 years become increasingly difficult to defend. States have opened to globalization with heavy emphasis on economic justifications. Public authority has become household management, politics policy. But the populist discovery of nationhood and traditional morality appear more as propaganda or cynicism than recent efforts to reconstruct public authority. Karen faced squarely the problem of how to justify state authority in a pluralist society. Her famous 1993 article, famous at least in the group where I read it in 1993, on feminism and state sovereignty, began with a normalist critique. Statehood limited women's participation in rulership, but it also sketched a public realm as a protective shield, occasionally open to women's concerns. There was room for women in public policy, she wrote. The text was a complex analysis of the pros and cons of statehood. All she wanted, she wrote there, was to make women conscious of the limits and possibilities of the use of statehood for what she called strategy of empowerment. That early work participated in post-Cold War identity politics and raised the difficulty of justifying public authority independently of special interests, in this case, the interests of women. She was skeptical about functional and strategic or moral justifications of statehood and landed, therefore, on pluralism. Public authority as the strategic accommodation of special interests. Her problem there was not to justify public authority, but to ask what its significance to women could be. In her later discussions on the nexus between statehood, territory, and people, she did accept that statehood had more than instrumental functions. It was to give effect to self-determination in some larger sense. The representative of publicness, as she wrote, of a state in view of crisscrossing identity claims was to be assisted by liberal procedures, well-known transparency and accountability. But these would not suffice to bring out a public voice that she called for. The attainment of that voice was a matter of struggle. And for that struggle, she suggested statehood provided a venue. And what kind of venue was it? In the spirit of Gauchet's stress on the period 1975-1985 as a watershed, Karen rejected both ethnos and demos as justifications for public authority. The debates about the independence of Quebec or the decisions of the ICJ on the West Africa were not about finding a nationhood, but assessing the persuasiveness of different narratives. Such narratives, she said, both reflect and create a sense of nationhood and are closely linked to each moment's political concerns. The international debates on self-determination in the 1990s that were the topic of her PhD thesis it highlighted especially the danger of pandemonium hovering over the heads of claimants of self-determination at the time. The world had become a dangerous place. The narratives, therefore, had turned into eminently practical, which people de facto are able to live together. No larger question need to be asked. But then, as she soberly concluded, at these debates left nobody really satisfied, reflected the fact that they were, in her words, embedded in a context of inequality and exclusion. Gauchet suggested that one element in the crisis of democracy was that there was no way of representing public authority independently from specific identity or interest claims. Hence the distrust of authority by interests or identity. Karen's writings on self-determination provide an excellent description of that predicament, the apparent irreducibility of pluralism. There was no given sense of nationhood for public authority to represent. The real situation was different. It was one of competing narratives about community and identity. But this didn't mean that engaging in the narrative would be impossible or pointless. It was only to be taken more seriously. A working statehood requires, she wrote, a high degree of need for and cultural attachment to a community. A high degree of need for and cultural attachment to a community. What else was cultural attachment and sensitivity to the many stories people used to tell what it was that bound them together? And it seems clear that a narrative deep enough to justify public authority would have to expand beyond the temporal moment of its narration. So the second pillar in Gauchet's story was the claim that the bond that links the parts of modern society now is constituted only by law, and especially individual rights situated at a higher level than the rest of the law. But, as I already said, if rights are predominantly about freedom from social bonds, how can they create those bonds? As feminists, Karen did not obviously think that societies consisted of autonomous individuals without bonds to others. Writing on the nationality of women, she put forward what she called a relational view that combined feminist scholarship with Benedict Anderson's imagined communities. A person has many relationships, she wrote, that could and should be reflected and encouraged even by nationality laws. She described the way European nationality law had first moved away from linking the wife's nationality with that of the husband to then recognizing the equality of the spouses and finally ending up where multiple nationality would cover multiple identities. She noted the way Council of Europe had recognized that spouses have sometimes good economic or emotional reasons to choose each other's nationality without losing their original one. She emphasized that as nationality may be chosen on the basis of family relations, it follows that public authority may sometimes be constructed from a private relationship. Or in her words, and I quote again, feelings for a state may be created by our feelings for particular members of that state. Unquote. The cultural and emotional bonds that link individuals together appeared everywhere in Karen's texts. She was interested in the tension between liberal equality claims, women's rights, and the rights of self-determination or community, questions that had arisen in the League period and in the UN. In her treatment of the Lovelace case, she noted how, absent an overriding political idea, the success of efforts to reconcile claims of culture and gender have depended on intricate assessments of their relative intensity. The task was, she wrote, to employ some intermediate concept in an attempt to do justice to identity, unquote. Again, stories stand at the forefront. Culture and gender may be logically incompatible from the perspective of an individual, even as they may be narrated as two elements of a single cultural practice. Today, law is everywhere, and human rights the last utopia. Social bonds articulated by claims of right that involve freedom from social bonds are a problem. For Gauchet, this is the peak of the crisis of democracy. The ubiquity of law and right undermine political culture by making accommodation harder, even impossible. Karen did not address that problem head on, but her writings on nationality and private international law notions, such as comity, focused on the cultural and interpretative functions of law and legal practice that mediate the hardness of rights claims. Rights may appear universal, but how we read them here may not at all be how they read it there, she put it. Public rhetoric may present rights as givens, but legal practice softens their edges. Yet this involves administrative or juridical discretion, reference to some higher criterion in a manner that enables putting claims of right in some hierarchy so as to decide between them. Where would such criterion come from? For Karen, all this relates to the politics of judging, or comparison and evaluation of claims of right may vary from one location and temporality to another. Everything, it seems, depends on how the legal authority is able to respond to the moment's cultural demands, without necessarily deciding between claims in any definite way, but offering a critical standpoint to each. This is an extraordinarily optimistic standpoint. Karen was surely no friend of excessive legalization of political culture. Many of her interventions aim to open up legal rules to cultural and political assessments, comparisons. There is a cultural politics of law, she suggests, that brought back some of the debate about the ways of living together in a democratic society that legalism otherwise tends to foreclose. Her work was nothing if not open to experiment and innovation. Now Karen agreed with Gauchet's third problem, then the absence of historical consciousness in the present. Ever since the failure of modernist development in the 1970s and 1980s, what remains has seemed to be naive faith in the globalization of a liberal cosmopolitan project, a faith built neither on the legacy of the past nor on any realistic future projection. Karen was interested in the turn to history in her discipline. She was especially interested in the narrative of the past that would explain present law's involvements in persisting injustices, the exclusion of women above all, but also more generally. She was interested in highlighting those exclusions as well, being the optimist as she was, and those occasional moments where the law did give space to people and groups who were otherwise sidelined. In her essay on the lost private side of international law, already referred to, Karen drew her readers' attention to the 18th and 19th centuries, where private gender relations were regarded as key parts of the law of nations. She pointed out to the apparently routine inclusion in law of certain cultural modes that appropriated attitudes traditionally linked with women. For example, the widespread use of comity and courtesy as specific types of interstate legality drew on softer approaches to civilized behavior, often linked with women. So her point was not, of course, to appropriate gender stereotypes, but to encourage cultural histories in the present that would allocate visibility to women's concerns and roles. She even suggested that attention to informal committee might usefully undermine the individualistic and self-interested images of sovereignty, highlighting what she called the state's social alter ego. In discussing the 19th century Scottish lawyer James Lorimer, usually remembered for his racism, Karen highlighted his attention to the notion of private citizen of the world, a notion whose incorporation in present international law should invite us, and let me quote her at some length, should invite us to compare discussions of the individual in contemporary public international law. What is inside and outside our frames of analysis? What do we foreground and what recedes? Whom do we privilege and whom do we miss? And when private citizens of the world are no longer in picture, are there current theories, critiques, proposals, and developments that capture some or all of that legal dimension? Karen was clear that the interest in the past was justifiable, even necessary, in view of the interest of the present, and acting in the present so as to create results for the future. This way of weaving past, present, and future together in an emancipatory frame is most visible, I think, in the essay that she co-wrote with Annelies Riles on the memory politics regarding Korean comfort women during World War II. The immediate background was a legal case decided in December 2015 concerning the removal of a memorial statue to commemorate the wrongs suffered by the comfort women in the Japanese army in front of the Japanese embassy in Seoul, South Korea. But the issue, when it was raised, did not at all limit itself to that single place or moment or that single controversy. The treatment of Korean women would arise at different times and at different jurisdictions with sometimes wholly different temporalities. They wrote together as follows. For a San Francisco politician who proposed a comfort women memorial for his city, or a Sydney minister who offered his church grounds as a home for a replica of the Seoul statue. Conversely, Korean American feminists in the United States may identify more strongly with the comfort women issue than some feminists in Korea, for whom the appropriation of the comfort women issue by nationalists is a pressing concern. As an issue of private international law, the comfort women theme involved Korean-Japanese relations, of course, but also issues relating to Korean diasporas around the world, women's movements and associations of victims in various locations. U.S. foreign affairs were concerned. Complex legal questions emerged. When were the crimes committed? Above all, how long did they persist? And do they persist today? What sort of violation was constituted by the years of silence about the matter, or its often inappropriate post-war treatment? Would statutes of limitation apply? And statutes of limitation in which country? What was to be the appropriate legal qualification? Private torts claim or claim about crimes against humanity, even genocide? As Karen wrote, the problem of what closure is possible or issues of historical gender injustice must be understood in light of the spatial and temporal diffusion of these issues. As the debates on colonialism and slavery have shown today, injustices extend, proliferate, reappear, and evolve in various forms and places, influenced by global circulations of people, resources, media, and legal arguments. This creates a complex, multi-layered understanding of time and space, where past events continually resurface and intersect with present and future contexts, resisting closure and resolution. None of this can be appropriately treated without some historical frame, without some sense of how this past is alive today, and what can be done to make sure that future generations learn. Again, its narration and cultural sensitivity, two of Karen's central concerns that are highlighted. Public authorities, nature of social bond between individuals, and experience of time in society. These are the three elements raised by Gauchet as the causes of democratic malaise today. In public debates, the culprit is often sought from neoliberal economic practices, but Gauchet suggests that although these are real, they are rather symptoms of problems in social structuration and our être ensemble. I don't think it's necessary to decide which direction the causal arrow points. As Nancy Fraser and others have argued, neoliberal capitalism is a cannibal, eating everything on its way. But it's true that merely operating within the institutional mechanisms of representative democracy, suggesting alternative governmental policies, is totally insufficient. Something about our être ensemble needs updating. I have suggested that this was Karen's project. She used self-determination as a point to rethink what it was that public authority could be. Whom could it represent? Whom should it represent? She did not think that humans were, first of all, autonomous individuals bonded predominantly by law and individual rights. And she insisted on cultural interpretations of the law that would bridge a community past to its present in view of future emancipation. She did not pretend to be able to solve the crisis of democracy. I don't think that expression existed in her text. She was far from seeking to over-dramatize things. She was sharp, honest, and optimistic, and that's why I miss our conversation so terribly.
It's a great honour to be here among friends and colleagues in these lectures that Karen herself would have given. Hearing her work resonate in thinking of others, and I do take that metaphor of hearing seriously. I have found her voice quite present to me as I prepared for these lectures, just as I found that I wasn't able to make sense of her work without the language of sight, the gaze, the regard that she had on the world. And in this, I know I'm in good company. Many people have been struck by the uniqueness of the way her eye fell on things and what that made possible. These references to physical processes of hearing and sight are, of course, doubled. In a literal sense, they imply a kind of intimacy, a nearness and particularism, but as metaphorical extensions, as shorthand for the kind of things we do as academics, they range very far from bodily presence. It's this kind of doubleness, the scalar fluidity that Karen had in moving from concrete to abstract, which seems to me really a through line of her work, as well as of her feminist politics. And that's a movement I'll try and stay in today. Martti and I were invited loosely to speak to history and theory, and I too will focus on Karen's early work on self-determination as a work of history and theory, or history as theory. It's a work that feels connected to many of Karen's later preoccupations, and maybe in some ways formative for her modes of inquiry. Self-determination also obviously remains an acute dilemma for international law, the system defining the limits of its own application. It poses this question of how we articulate the relations between people and peoples, territory, political authority, how political order is generated, what self-government means, what kind of societies exist, what kind of an international society we might expect to emerge. In Karen's doctorate, which yielded the book Diversity and Self-Determination in International Law, was written at a particular time in the 1990s, when struggles over self-determination felt present and persistent, yet perhaps also somehow residual, a legacy of colonialism and of what would then more confidently be labelled the end of the Cold War. The question of self-determination is now resonant again, from Palestine to Chagos, Ukraine to Greenland, and those of us who are habituated to living in advanced democracies which felt self-determining and stable are now experiencing some minor semblance of the dislocation and lack of control, which is the norm for other polities on a permanent basis. So, one possibility would be to try and update Karen's account chronologically, to add another 20-something years of rich interpretive maneuvers to the sequence. I've opted not to do this. This isn't because recent jurisprudence, particularly on Palestine or on Chagos, isn't historically important, politically foundational. It is. But in many ways, I think the doctrinal discussion about these matters remains very much as Karen characterized. I want to take up a slightly different question she posed. Is there room, her words, in the interpretation of international law for a conversation about the meaning of self-determination? And if so, what sort of a conversation can we have? So at a moment when self-determination feels not only a right, principle, but also something larger, a placeholder maybe for argument about an international society that we want to live in, I want to revisit some of this past terrain that Karen covered in sympathy with the bounds of Karen's method, to see whether we can take self-determination loose a little from its doctrinal moorings and resituate it as a question in and for international law. This revisiting of self-determination seems to me one counterpart of the project that Martti traces in the work of Marcel Gauchet on democracy. Gauchet is attempting to reanimate thinking about liberal democracy in particular, part of his French movement to find, elucidate the value in the particular variant of liberal democracy as a complex mixed system that's capable of stabilizing social change. The analysis, as you will have heard from Martti, is a long-range one, right, in which the malaise of liberal democracy today is inseparable from the loss in the West, at least, of the sense of unity between people and across time offered by religion. Absent this anchoring, the mechanisms of democratic governance and rule of law might have been perfected, but the real power, to take Gauchet's words, has deserted the machinery. And this is, for Gauchet, keyed into processes of globalization and individualization, which reached a height in the 1980s, coinciding not only the oil shocks and financialization, but the loss of any geopolitical enemy of democracy. And as both Karen and Susan Marks have observed, the thinning out of the idea of democracy itself in international law to quite basic models of electoral competition, even as it became, more plausibly, a globalized norm of rule. In Gauchet's account, law, and perhaps particularly rights, ideal of rule of law, have taken on far greater prominence than they can really bear in the definition of any collective project or universal. And there is an urgent need to remake these interconnections between the political, legal, and historical. As Martti suggests, features of Karen's thought and writing nuance this narrative by insisting on narrative. Karen's illustration of the interpretive play inherent to law qualifies, I think, the impression that law has, like some kind of aggressive weed, colonized the landscape and drawn up all the resources and vitality from other languages. Karen's thought is also anti-foundational. It's resistant to the notion of a kind of lost holism, which I think is fundamental to the analysis of someone like Gauchet. There isn't, in diversity and self-determination, an ex-ante social, at least as a category that's freighted with historical meaning. There's only the convergence of these terms that she uses: identity and participation, how law frames groups and how groups participate in law and legal interpretation, and this quiet insistence that familial, amical, religious, economic, linguistic, cultural, and other ties might all be part of the picture. Indeed, although Karen's analysis is rooted in international law, she took from this a program for legal interpretation generally in, to use her words, transitional, multinational, and plural societies. So plural societies and societies plural is significant, and her descriptors are broad enough to capture our domestic and our international realms and much that moves in between them. So I think that where Martti and I meet is on this terrain of remaking, animated by Karen's thought. If the task is, as Gauchet sees it, a renewal of democracy through remaking connections between the political, legal, and historical, this is no longer, if it ever was, a project which is capable of containment within the nation state, however conceived. An abstract universal is also out of reach. If we have to think now on a larger and more particular canvas, some bigger, more sprawling social, then self-determination as right, principle, and perhaps some larger touchstone for thought and action seems a kind of parallel to democracy, another place from which to begin. Karen's work is a unique entry point to any thinking about self-determination. The dissertation and the book moved at a real tangent to existing scholarship. The conventional bounds of legal argument about self-determination became for her seams for further investigation, the right of secession not one to be defined and pinned down, but rather explored, in Karen's words, as a place perhaps without equal, where international law has had to contend with the challenge of diversity for its application. And I just open a bracket here to posit that she might have been writing at a point in time in which diversity had begun its rise to linguistic prominence, but was perhaps not yet frozen in its current, more banal form. So there's a sort of energy in that term which might have gone to other places in different directions than where it has in fact gone. In exploring how the law on self-determination engaged diversity, Karen's work took up what she called successive encounters with the marginalized. She wove into her text the rhetoric of post-World War I plebiscitary campaigns, the voices of women in trust territories, their complaints about legal status, material relations, being passed over in the queues in shops, seeing their children walk to school while others were bussed. Again, these very sudden moments of proximity, visceral insults to dignity, pop up in the text in ways that would, I think, have been very disorienting to anyone who was expecting an orthodox sources analysis. Nevertheless, her exploration did centre on the workings of law. The work was self-evidently not engaged in distilling from the cases a particular account of the right to secede, but nor, as some of her critics noted, was her work wholly embedded in the perspective of the marginalised or excluded groups she wrote about, even if that's something that would have been attainable. It wasn't even particularly bound up with analysing the consequences for these groups of the interpretive processes she examined. To pick up the restatement of her work she offered in a response to critics, she was interested in the play of interpretation in courts or commissions or negotiations, exploring how interpretive responses, in her words, were unified by some combination of attention to identity, meaning the law's depiction of a group's identity, and participation, meaning the actual involvement of a group or other means of incorporating a consideration of its perspectives. There's something in the suspensiveness of this analytical position, the unfixity of it, which both unlocks the argument of the book and animates much of her other work. It brings with it, I think, ability to see what others order as public, private, foreign, domestic, indigenous, minority, all kind of enfolded within each other, and an ability to see individuals and collectivities moving in, constituting relations in these multiple dimensions all at once. This distinctive gaze brings into view human subjects as agentic, generative, as David Eisenhower puts it, part constructors of their legal and social worlds, in ways that leave states faint outlines in the background. So rereading Diversity and Self-Determination, I was struck by this startlingly open, unsettled horizon in legal treatment. I also found the text arresting in another respect. So the very pared back focus on legal interpretation feels almost austere now against the intensity of the rich historical work that's been done on many of the episodes that feature in her account. What I want to do is stay faithful to her focus on legal interpretation, the horizons her gaze opens up, the agency it locates in subjects, but press slightly on the boundaries of where we think legal interpretation happens. So my eye is drawn to sites upstream of courts and public negotiations, including those sites which constrain where and how self-determination is ever adjudicated in more public fora. In these sites, identity in Karen's sense, law's framing of groups, might still be playing a crucial role, but participation might be more constrained, uneven. The story might be one of lack or absence rather than presence. Looking outwards to these different sites of legal interpretation might be a way of having a different conversation about self-determination and reopening its relationship with other concepts. I'll take 3 avenues into this, and I start with the foundational divide between self-determination in the sense of a people's status and in the sense of their control over the politics of interstate relations. These 2 poles are themselves, in some kind of meta way, something like identity and participation in Karen's terms. I start with the voices at Karen cites seeking women's suffrage in the patchwork of plebiscites held after World War I. Karen quotes a joint delegation from the Conference of Women Suffragists of the Allied countries and the US, and the International Council of Women. All these bodies had very elaborate names. And she was definitely alive to the unique access that these white, predominantly American or British women enjoyed to the negotiation of the Covenant of the League of Nations by virtue of the liberal networks which ran through the White House. The delegation demands referred to the profound injustice, in their words, that women who lack the vote are without a voice in the government of their country, can take no part in the decisions which may give rise to war or peace. The delegation's immediate priority is the arrangements for voting in plebiscites. Their larger preoccupations are full participation in what they call the political life of nations, rooted inter alia in women's standing as furnishing, their words, what might be called the human material for war. So it's, again, perhaps worth opening a bracket to underline the shock of this statement, 100 years old. Very deep-rooted association of womanhood with mothering, but reformulated neatly to fit women into the wartime state as an industrial machine. What interests me particularly, though, is the openness of the demands of these women to take part in the decisions which may give rise to war or peace. If we read this statement literally, it opens a very large horizon. But there was a strong bifurcation in wartime activism and at the Paris Peace Conference, virtually across the political spectrum, between the problematique of self-determination on one hand, applied to the remnants of collapsed empires, but definitely not the extant empires of the victors, and the problematique of what was sometimes called popular control or democratic control of foreign policy on the other. Also, it has to be said, confined largely to the metropole. Women's organizations were central to both demands for formal self-determination processes and to the denunciation of secret diplomacy and the grip of aristocratic or moneyed interests on interstate relations. In the plebiscites, full realization of self-determination was thought to demand a universal adult suffrage. Attention to the electorate forcing here a closer look at the relationship of the actual population to the conception of a people and a self to be determined. In America and the Allied powers, the elections before and during peacemaking and all the pathologies of the interstate negotiation at Paris under the influence of electoral politics and press agitation also placed democracy under scrutiny. But here the solutions were much more elusive than expansion of the suffrage. Indeed, to many observers, it was precisely democratic politics which complicated the realization of a peace premised on self-determination. So while this language of self-determination retained its force as a language fit anti-imperial organizing, it was not, in Anglo-American thought at least, a vehicle for thinking through the challenge of stabilizing international politics under conditions of mass democracy within states or empires already recognized in the international realm. Attentiveness to the legal interpretation already ongoing in peacemaking processes at Brest-Litovsk and at Paris, the framing of the terms taking place in these negotiations, and in transnational movements which were trying to steer and respond to them, brings out, I think, a certain symmetry between self-determination and the question of status in the international realm, its imagined moment of extrusion into an inter-imperial and interstate system, on one hand, and what we have tended to see as the more sedate, bounded, easier challenges of popular control of diplomacy within the existing borders of states. There is, though, a core shared dilemma here about what it is to live in social and political orders which are responsive and outward-facing others, the permanent vulnerability that this creates, the febrile grasp of democracy on questions which might be fundamental to the state's survival and future form. A second way of questioning the conceptual boundaries of self-determination, taking shape prior for much of the more obvious jurisprudence, is the interface of self-determination with the economic. This has, of course, been the subject of extensive, explicit public legal argument and much rich scholarship. In debates over economic coercion, explicit efforts to remake the international economic order. More recently, thinking about supply chains, about governance, about the material. But Karen's work reminds us of the layered way in which the economic might be enfolded in other, more peripheral or concealed sites of legal interpretation, or sites which set the parameters of other legal interpretation. At the most intimate and quotidian end of the spectrum, these concerns are present in the petitions of women to the trusteeship council. Karen highlights, for example, the way in which one 1950 petition from the Women's Committee of the Union of the Populations of Cameroon, UPC, complains of the way Cameroonian women are sidelined in shops until after white women and their servants are served, and are unable to work as seamstresses even in their homes because they are required to license. So here we have racial and regulatory rule constraining the self-conscious experience of economic freedom. But the Women's Committee were also part of a larger project of the UPC, which was a very protean, transnationally active movement seeking the union of British and French Cameroon and then independence, rather than a gradual transition of each former colony within the legal and political parameters of the existing colonial administration. The very framing of such a movement is a statement and an artifact of participation, part of what Greta Chu and Emma Hunter and others have explored as a larger movement of challenge to colonial boundary and of vessels for post-colonial political authority. The fate of the UPC and its vision would be determined in part through legal relations between the colonial administration, later government, and the French metropole. The UPC was outlawed in French Cameroon in 1955, and French negotiations with Amadou Ahidjo, Prime Minister later of French Cameroon, focused on managing the threat the UPC and its alternative vision would pose to Ahidjo's rule. Provisional legal arrangements made as independence approached included a secret exchange of personal letters between Ahidjo and his French counterparts, providing for use of French troops nominally under the responsibility of the Cameroonian government against the UPC rebel. French troops destroyed UPC training camps and engaged in what even the French ambassador privately described as brutal reprisals. This is a conflict which lasted years, and post-independence, these arrangements were superseded by further secret and formal accords providing permanently for defence arrangement, including the possibility of requesting assistance of French forces for maintenance of internal order, and, crucially, for French access to strategic primary resources. The French African post-colony was sometimes referred to as the pré carré, something like a private pasture, a term which captures exactly the framing here as a field for the exercise of something like feudal overlordship and protection, as well as a resource to be plumbed by that expression. This is not a backdrop to the exercise of post-colonial self-determination, but in different forms and to different extents integral to its legal architecture, even if not public at the time. The instruments, the very possibility of these secret legally binding accords, had been built into the foreign relations law of new states, which were themselves a transmission of the uneasy settlement between democracy and executive control of foreign relations that had taken shape in the interwar years, in that diffuse field of popular control of foreign policy that had already been hived off from the main conception of self-determination in international law. To shift context and chronology, we might explore also the hinterland of the East Timor proceedings in the ICJ. Karen's focus in the book is on the court's handling of rival arguments as between Portugal and Australia on admissibility. But the substantive subject matter underlying this dispute is Australia's rapid de jure recognition of Indonesian station, which was a prerequisite to joint development of the Timor Sea oil and gas field. Australia would go on ultimately to support the holding of a referendum on independence in East Timor, but subsequent negotiations between Australia and the new state, post-dating diversity and self-determination, involved Australia's Foreign Intelligence Agency planting listening devices in a room adjacent to the office of the Prime Minister of Timor-Leste, under cover of an aid operation for renovation of their cabinet office. And the Australian government using access to high-level discussions in Dili to the benefit of Australia and ultimately corporate partners in the joint venture that would operate under the treaty. Many of the legal challenges relating to these developments in different courts and fora, which were disclosed by an intelligence operative uncomfortable with the operation, have been settled, as we can anticipate prior to formal resolution. But the crafting of operations like this and the struggles for renegotiation of the treaty in the wake of the revelations of the operation are also sites in which self-determination is interpreted and participation is expanded or throttled. The third and final conceptual boundary I want to think about is that between self-determination and broader understandings of the social fabric of interstate transnational relations. Resolution 1541 sets out familiarly modes of self-government as independence, free association, or integration. Free association being the result of a free and voluntary choice by the peoples of the territory concerned, expressed through informed and democratic processes. Both this stipulation of end and of process and the applicability of self-determination to peoples subject to alien subjugation, domination, and exploitation, Resolution 1514, posit self-determination as a passage to non-domination. The people, a kind of generic liberal identity, to quote Karen. Yet it is a passage also into an already existing fabric of norms and commitments, from the material to the institutional to the sentimental and affective. The passage to independence of both French Cameroon, later Republic of Cameroon, and East Timor, Timor-Leste, reflect the material realities of emergence to independence. The omnipresence of constraint here is, of course, well understood, and it intersects with the more general theoretical impasse of international law, the balancing of a nominally consensual system with realities of force, manifest in everything from the limited circumstances in which coercion renders a putative treaty void ab initio, to the relatively underdeveloped theorization of the prohibition of threat of force, and the tenor of obligations on states to settle disputes peacefully, but not necessarily in accordance with the rights and duties that each party might have under law. The social fabric into which states emerge is, of course, institutionalized, and self-determination now is, I think, impossible to conceive without confronting the vital role played by institutional actors of one kind or another. Multilateral organizations, I guess most obviously, in which office and internal politics and bureaucratic process inflect state positions and shift the dynamics and the sites of interpretation, as well as the language and gestures which are themselves being interpreted. I think there might be scope here to put in conversation the quite distinct lines of thinking and scholarship about self-determination of peoples and the legal personality of international organizations and the social processes involved in each. Finally, as Karen's contribution to the History Politics Law collection argued, there are myriad affinities between and among states. This is something on which Martti touched. Self-determination is necessarily participation in relations figured as solidarity, fraternity, friendship, alliance. Such relations are often themselves gendered, and they are illuminated by a gender perspective. They might teeter between the coercive and the voluntarist. They might be rooted in anything from shared history and language to very contingent convergence of goals. These affinities are often expressed as extra-legal or pre-legal, but relations of alliance, for example, have long been constructed as complex amalgams of law and something beyond law. Precisely what these affinities entail is rarely a question presented for adjudication or even public negotiation in any direct way. Certainly not in the sites of legal interpretation in which Karen is preoccupied. But the questions of identity at stake are foundational to the legal order, to the institutions we create, the way we live in and across borders. What I've tried to do here is harness Karen's gaze in dealing with the international, the perspectives on and agency that she brings alive in other actors. I've held to a focus on interpretation, on the interplay of law's depiction of groups and groups' own participation in the interpretive process. But I've drawn on what I think is a resource of Karen's work, her open-ended ecumenical sense of who interprets, to push outward to a greater range of scenes of interpretation, sites at which the fundamental categories and silos of doctrine are consolidated. I have the intuition I think she had that there's more to say about self-determination, not necessarily as right or doctrine, but as a place from which, to paraphrase Karen, we ask new questions and have new conversations about international law as a project of coexistence in diversity.